Hi viewers, you are well aware that I am Dr. Jetning Yellow sir, running a YouTube channel called Law Speeches, in which I am posting my lectures on various facets of law and also issues pertaining to the national international affairs. And today, if you refer any newspaper in India, the headline item is the Supreme Court landmark decision on the abrogation of the electoral bonds. Yesterday, the Supreme Court had pronounced the landmark decision which affecting almost all the political parties, and also it opened the gateway of the freedom of speech and expression, and also under which we have the Right to Information Act is there. So before going inside, we have to discuss what is meant by the electoral bonds. In 2017 and 18 budget, then Finance Minister has introduced that individuals are the domestic companies, they can give donations by way of purchasing the electoral bonds in the State Bank of India. And the bonds were available in denomination of 1,000, 10,000 rupees, 1 lakh, 10 lakhs, and also 1 crore. And the scheme provided the amendment to the Income Tax Act, Representation of Peoples Act, and also the Companies Act. So the individuals are the domestic companies, they can purchase these bonds in the State Bank of India, and the amount of the bond can be transferred to their political party which they are like, and the political party has to redeem this bond into cash within 15 days of such receipt of the bond. So, unlimited way these bonds can be purchased, and the political parties, after redeeming the bond, they have to, within 15 days, they have to deposit with the Prime Minister National Assistance Account. This is a broad spectrum of the scheme of electoral bonds. You know, after the 2019 elections were conducted to the Lok Sabha, and the scheme was continued till date, and there are, as per data says, that there were 16,000 crores bonds were purchased by individuals and the domesticated companies, and they have given such purchasing bonds to different political parties, and much of the amount was, around 55% of amount was gone to the ruling Bharatiya Janata Party. And the Congress has got 9.3% of the bonds, and then different parties have got some ratio of these bonds. And so by these accounts we can say that the ruling BJP party is a highest income generator from these bonds. And so there is a kind of money has floated into the political parties, which has caused a lot of effect upon the democratic process. And one more aspect is that the political parties have not to reveal, or the individuals are denied of information how much the political parties have claimed they got the donations from the public or domesticated companies. So the question came to the number of public spirited persons. This hidden sort of transactions may cause a cascading effect upon the democratic process. Black money will come into the hands of the political parties. It would have, and the elections may become the money-oriented elections. So with that view, and it has impacted upon the freedom of speech and expression which is guaranteed under the Article 19 class 1 and E subclass A, where right to freedom of speech and expression is there, under which we got the right to information, and we have passed the Right to Information Act in 2005. So these public spirited persons like the Association of Democratic Reforms, shortly called as ADR, the petitioner, the first petitioner, and the Common Cause is another petitioner represented by the Anjali Bharadwaja, and some more associations have filed a writ petition in the Supreme Court of India, challenging the constitutional validity of the issuing of the electoral bonds and denying of information with regard to such electoral bonds. And finally, the government, the respondent side and the petitioners, they argued, and the petitioners, they argued that it may lead to a mockery upon the democratic process, and money plays very bigger role in election process. It affects upon the entire democratic gamut. The other side, union government argued that no, these are must for smooth functioning of democracy and to unearthing the black money. That was the argument. And the arguments were concluded on November 2nd of 2023, and yesterday the judgment has come. The 5-member Supreme Court full bench, including Justices Chandrachud, Sanjeev Khanna, B.R. Gawai, J.B. Pardiwala, and Manoj Mishra, these honorable judges unanimously had struck down this scheme of issuing the electoral bonds. So they opined that the issuing of electoral bonds is nothing but complete violation and negation of the constitutional spirit. And they also held that voters' right to information is completely violated. And political funding, how they get the political parties, how getting the money, that should be revealed to the public. And the Right to Information Act under the Article 19, clause number 1 and subclause number A of the Constitution of India. It is a fundamental right of every voter to know how their political parties are getting money. And the Chief Justice Chandrachud had remarked that the non-disclosure of source of political funding promotes corruption, and it is a culture of quid pro quo with the ruling party. So all judges who had heard the matter have unanimously held it is not having the constitutional validity, and is directed the union government immediately stop the electoral bonds scheme, and also directed the State Bank of India, who is issued these bonds, to give information by March 6th of 2024, and all those non-cash bonds should be returned back to the applicants or customers, and is also directed the Election Commission of India to reveal all the information, how much the political parties they have got collected of electoral bonds information, and they have to put it in their website by 13th of March 2024. So this is a very, very landmark judgment, we can say, and immediately the different political parties have opined, like the Congress party has stated that it is nothing but it is created the level playing field in the election process, because some party getting the more funding and non-ruling parties they getting lesser funding may lead to not equal playing in the political elections. And the ruling BJP party has remarked that we brought this scheme for the purpose of transparency and because of the avoiding corruption in the elections and to curb the black money in the market. And the other political parties like the Samajwadi Party had remarked that it is nothing but victory, a revival of democracy in India. And the Aam Aadmi Party has opined that it is a important step for the transparency of election funding. And the Communist Party of Marxist of India and Marxist, it stated that it exposed the murky deals in the election process. So the petitioners who filed the case, ADR, which filed the case, they opined, they stated that it's a big win for democracy, for which our freedom struggle was fought. That was our opinion. And the eminent Supreme Court advocate, the Prashant Bhushan, he opined that it is a salutary judgment which enhances our democratic process. So, the system of electoral bonds has been negated by the Supreme Court, apex court of the land, and the Justice Sanjeev Khanna also in his opinion judgment stated he availed the doctrine of proportionality in this judgment. So this is a very landmark judgments which have a lot of effect upon in years to come in election process is concerned, because election should be a free, fair and level playing field, not it should be one-sided. And the Election Commission of India should take note of these things, and so democracy should be survive if we maintain unfairness, if we maintain fairness in the election process. There should not be any sort of unfairness at any form. So thank you for listening my lecture, and I again call upon you to subscribe to my channel and give your valuable comments and opinions and propagate my channel. And the channel is only meant for the purpose of propagation of the legal knowledge. Thank you, one and all.